Good day to everyone, and welcome to what is the third installment of the CAJO's Law and Logic series. This series is a series in which the CAJO has conversations with prominent jurists. Today we have the great honor and great pleasure as our interviewee, Justice Rolston Nelson. Justice Nelson is, in his own right, an acclaimed jurist. He joined the Trinidad and Tobago bench at the Court of Appeal, was part of the original cohort of judges at the CCJ, and left the CCJ in 2017. Before he even became a judge, Justice Nelson was a very well-regarded, well-respected practitioner. He attained the status of Senior Counsel at the Bar of Trinidad and Tobago and was awarded the National Award of Shakonia Medal Gold in acknowledgement and recognition of his contributions to law and society. So we are very privileged to have Justice Nelson with us and to have this conversation with him. I'm going to be a little less formal, and as we move along, I'm going to refer to him as Rolston, and he's going to say Peter, so that this becomes easier for all of us to follow and a little more relaxed. So without any further introductions, Rolston. Good morning.
Good morning, learned Justice Jamadar. I am very happy and honored to be invited to share some thoughts with him and also the cohort of Caribbean judicial officers. Much of what he said is very flattering, and I hope what I am going to say does not disappoint you.
It won't at all, and I haven't said the half of it. I haven't spoken about all your publications, the articles, the research. So, you know, there is so much.
Yes, well, it's been a long time, I suppose.
Yes.
Some almost 50 years.
But let's start not at the end, but at the beginning.
Yes.
And what I want to ask is, what drew you to the law? And can you maybe just walk us a little bit through that journey?
Well, I remember in the sixth form at my school, Queen's Royal College, I went to the library and I saw a publication which the British Council had sent to the library by Lord Denning, and it was about justice. I sat and I read it, and I was astounded by the clarity of thought and the clarity of the language that was expressed. It had a tremendous effect on me. I ran down to the college hall and I looked at the honor roll, and I looked up at those people whose names were inscribed on the wall. And it struck me that the most prominent honorees were all lawyers. So Hugh Wooding and Sir Leonard Courtney Hannes. So I said, look, I would like to be like these people. However, my main draw at the time were my masters, who were my idols, people who taught me French, Spanish, and Latin. But the pull of that experience kept gnawing at me. And eventually, when I won a national scholarship, I decided that I would study not only modern languages, but also jurisprudence at Oxford. And that is how I got introduced to law. When I got to Oxford, I was able to sit at the feet of Professor Wade, H.R.W. Wade. In those days, administrative law was in its infancy. In those days, human rights law was also in its infancy. I heard Sir Ivor Jennings at the common law level, I sat at the feet of Professor Tritle, Professor Tia, and the redoubtable Professor Rupert Cross, who was totally blind.
Is that right?
Yeah.
Cross on evidence we talked about. Right. Yeah.
So blind.
I wasn't aware of that.
I think he something happened during his early childhood and he was blind for life. So those were the influences at that level. And then
would you timestamp that for us, just so we get not a sense of your age, but
yes,
we
but
put in
that
the
was in the 70s.
Right, yes.
Sorry, it actually was in the 60s.
Yes.
It was late 60s.
Yeah. So you left Trinidad.
I left Trinidad in about soon after independence.
And so tell us, just not even about law. How did you travel from here to London in those days?
In those days, you traveled by transatlantic liner.
Yeah. How long did that take?
And that took at least 15 days, and it was direct flight, direct journey.
What was that like for you?
It was new. It's the first time I'd been on a large ship.
Yeah.
There were a lot of Australians and New Zealanders returning. Well, I say Australians and New Zealanders. I mean, English people who were living there were going home to go back to New Zealand. Anyway, they were quite nice, and I first time I met Australians and New Zealanders, and that journey took about 10 days. No, 10 or 12 days, yeah.
And you landed where in Southampton?
Southampton,
right, yes.
And then you took the train into London,
right,
where the British Council met you.
And did you have digs or residence when you were at Oxford?
At Oxford, I was both in digs and in residence.
Right.
And so that I had much experience of living in college and out of college.
Yeah.
So that is where one made one's friends. You met people like Nawab Fatawi was the captain of the...
Yeah, that's right. Some of these sort of anecdotal things, I think, add a little texture to the person who is Rolston and to the lawyer that Rolston would become, and then the judge, So what would you say was some of the, just to take a little step back and then into Trinidad and then the journey, and then you're Oxford. What would you say have been the influences? In people, maybe also people, but what do you think would be the things that may have been influencing you in those formative years, as it were?
Well, in one of the things that, one of the main thoughts going around at that time was national independence. I mean, Trinidad was moving from a colony to an independent nation. And the call was for young people to educate themselves and come back and make a contribution. So that, unlike some of the modern youth, I mean, they're not terribly concerned. The world is a village as far as they're concerned. So it doesn't matter whether they're in India or USA. But in those days, the commitment, the feeling was, I have to educate myself in order to make a contribution to Trinidad and Tobago.
And you had that strong sentiment.
That was a strong sentiment. And
would you say that is something that, as your career unfolded, played out as an undertone to how you approached your life and the law and your practice?
I would say so. Mind you, I think the idea of the British colonial governance was that the local people should be educated enough to run the country on behalf of the British government.
Right, yes.
So in a sense, a lot of opportunities were given, and that one was grateful for that, and one always had felt the obligation to return the to pay back, so to speak, the benefits that one was getting. And for example, I would not have been able to afford to go to university. And the fact that I was able to go to university, and one of the bigger universities, UE was still in its infancy, didn't even have a faculty of law. The fact that I was able to get where I got to meant that I had an obligation to take what I could get from that experience and come back and allow other people to have that similar experience.
Yes.
That is the commitment we had in those days.
Yeah. And I think as we go along in this interview, I think we'll circle back to that.
Yes.
When we come to maybe the transitions from practitioner to bench. But let's pause a little bit and maybe just shift gears slightly, but on the same sort of theme, and to ask, are there any experiences that you may have had as a young person now? This is before advanced level or higher certificate, whatever it was, at the time, that you think impacted you as you journeyed through law? Maybe experiences when you were growing up, or experiences with your family or socially. Anything that you can cast your mind back to that you think, these things impacted me?
Yeah, well, I'm sure there are a lot of things that impacted me, but to say that I can single out any particular incident as being more impactful than the other, I wouldn't say so. Of course, one of the critical factors was that in those days, you had a lot of the masters coming to presentation, QRC, and all those. They were actually people from other places. Some of them are very erudite.
Yes.
And when I take, for example, a master like W.D. Isaac, who was really capable of teaching at Oxford, but chose to teach at QRC.
Yes, yes.
Extremely learned.
Yes.
And a class of 45 minutes could take you into the depths of Shakespeare, criticism of what Cicero said.
Your eyes light up with those memories, but were those impactful for you?
Oh, very impactful. I was very impressed by that kind of scholarship and that kind of learning.
Yeah. And do you think that excited in you this inclination to scholarship and learning, which has punctuated your career?
Very, 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 very much so. I'm certain that is why I took to, at first tended towards an academic life, eventually deciding against it. But the quest for learning, the quest for knowledge, became virtually insatiable.
For you?
Yeah.
Tell us a little bit about this foray into the academic life.
Well, as you know, I started in London. I started teaching at sort of in those days they called them was a sort of semi-university type situation. But you got degrees, but it was not the London degree.
Yes. Is it what we would call the polytechnic?
Polytechnic type.
Yes, yeah.
I started teaching there. Then I started teaching at the Inns of Court School of Law, private tutors. And from there, I began teaching. I got the post at Norman Manley Law School to teach law in the first cohort of or the pioneering group of local legal education. So that I was there. I went to Norman Manley on the Mona campus to teach law, and when I arrived on the campus, I said to the driver, "Could you take me to the Norman Manley Law School?" And he stopped at what I thought was a hut.
Yeah.
And he said, "That is the law school."
Yeah. I suppose you're coming from Oxford.
Yeah.
You're coming from what a law school feels and looks like in Oxford.
Yes, exactly.
And then
and so that was a crushing blow. I said, "There's nothing here."
Yes, yes. And yet still, you stayed and gave time and effort to build.
That's right. That is, there was that commitment.
Yeah.
We had to do it. We had to succeed.
Yes.
We had to indigenize legal education in the Caribbean.
And you've been dedicated to that for your entire life?
Yes, exactly.
Long after the law...
Yes, I mean, last year I didn't teach at the law school, but I mean, ever since 1973.
You've been teaching.
I've been teaching at the law school.
And I think that's one of the things that earmarks this legal career of yours, this commitment to the development of law and the willingness to work, because you're not working in the law schools for great pay. It's more service than pay.
It's more service than pay.
But you were willing to do it. Let's shift gears a little bit, if you would, Rolston, and to move to reasoning now. And so when you are faced with complex legal dilemmas, but maybe first, for you, what would be a complex legal dilemma? But then, importantly, how would you sort of respond to that? So I want to sort of segue from your early years, career paths and trends, and now look a little bit more at legal reasoning.
Yes, well, I've been thinking about how I approach legal reasoning, and I think basically I'm thrown back on what Oliver Wendell Holmes said. The life of the law is not logic; it has been experience. And when I think about how I approach things, I realize that we lawyers start with something called law. That is the established norms that we think the society accepts. And there's a type of reasoning which says that, almost mathematical, that if I look at the pleadings, I look at the facts, if I look at the issues, and I look at the relevant law, I can apply the relevant law to the facts, and I will get the answer.
Like an equation, a mathematical equation.
Mathematical equation.
But
yes, you asked about influences and so on, but I think Oliver Wendell Holmes, way back in the 1880s, is telling you that is not so. He says that logic is not the life of the law.
Yes.
The life of the law is experience. Yes. So that experience is something that, I mean, so far I've not been able to pinpoint what has impacted my entry into law.
Yes.
But it is that unseen, that hidden influence at the back of your mind that is important, and there's no gainsaying it, that it applies. Why does it apply? It applies because the norms that you develop from to make rules, they are applied to certain types of behavior. But human behavior is infinite, and therefore there are going to be gaps. There are going to be cases where lawyers or judges have to apply judicial discretion. And, when you talk about the balancing exercise, it really worries me sometimes, because I said that this question is going all over the place. What is the law?
Yeah. But what are we struggling with in that moment? In that moment when the equation of the law is somehow not satisfying something in us, what's the struggle? If you had to try and express from your experience, what is the struggle that's going on in you in those moments where logic is not the law, but experience is?
That is where I find a lot of difficulty, because, the judge is saying, I want to find the answer. In fact, I must find the answer.
Mm-hmm.
I must find an answer.
Mm-hmm.
And the question is, how are you going to find an answer when there are so many possible answers? Why do you think your answer is right? Now, what I apply is I say, well, look, my object is to be fair and just. We are ordinary human beings, and we may not succeed, but the effort has to be made to be fair and just.
Would you say those are your two fundamental core operating principles?
Yes, I would say so. That is really, at the end of the day, my leitmotif in everything. So I apply the law, and very often when you apply the law to the facts, you don't get the outcome you think is right. Now, what I would do is I would say, let me go back and look at the facts and the law. Let me analyze the law a little deeper to see whether, in fact, this is really a principle at all.
And isn't that interrogation where fairness and justice are intersecting with the normative, conventional interpretation of law? And isn't it that interrogation, that point, that leads to the development of the law?
Exactly. Yeah, that does lead to the development of the law. And, because we are not omniscient, there will always be opportunities or occasions when there is a flash of illumination, and everything suddenly seems to make a lot more sense. When you have new principles being developed out of old principles, and that is what is exciting about the law. Now,
I could see your eyes light up when you say that, and no, but it's true.
Yeah.
As lawyers, as judges, you get that moment when it's this could be the way.
Yes.
Do you have an example maybe that you can share with us of where during your career?
Well, I don't know. I think there are cases where, like the Romeo da Costa Hall case.
Yes.
Where a man is in the remand yard for, I think it was 4.5 years, and he's convicted, but after 4.5 years, and you say to him, well, I'm giving you a discount of 2 years, and he says, what?
Yes.
He said, I've been in prison for 4.5 years.
Yes.
So you then begin to think, well, is this fair or just? And you then begin to think, well, why can't I backdate it? Well, it says, well, you can't, because there's no statute that allows you to do that. So you then say, well, what is the answer? And eventually, myself and my colleagues came to the decision that, look, the answer is to give him full credit for the time spent on the remand yard. You see, and that was one of those occasions where...
And that then becomes an established principle.
Yes, that became...
And that now is applied throughout the Caribbean region.
Yes.
Give him full credit
Yes.
for time spent.
So, yeah.
We now say that as if, oh, we take it for granted.
Yes,
you had to struggle with getting there.
Yeah, we did. Yes, we did. We did struggle to get there.
But what I hear is, in this complex legal situation, you come back to fair and just.
Yes.
In terms of circumstance and fact and experience, and you come back to that and come back to that, and almost wait for the solution to sort of.
That's very much the case. Yes.
Yeah. When you feel you're under pressure, there are some cases in which, you have parties and it's limited to the court and the parties, and that's fine. We doesn't make it easier.
Yeah.
But then there are the cases when we know everybody's looking on.
Yes. Yeah.
Everybody's looking on.
Yeah.
And those can be very challenging for any judge.
Yes.
But especially for judges who have, for example, just become judges.
Yes, exactly.
Now, you entered at the appellate level, but of course there are first-year judges who have to deal with high-profile cases.
Yes.
How did you manage in your own career when you are faced with these high-profile cases and the competing voices? The society is saying, this is what we think justice is. There are advocates or advocacy groups saying something, and the world is looking on, as it were.
Yes. In the early days, judges going into court, they used to boast that they never read the papers before they went to court. But that is not now the case. And I think judges, whether they're in the Privy Council or not, have heard about the case. I think it's no point pretending that you're not hearing, because everybody will think you're hearing.
Mm-hmm. Mm-hmm.
But there's a tremendous exercise in self-control that one has to implement in such a situation.
I want you to share a little bit about this, because part of our viewing audience is going to be judicial officers who have just embarked on their career, but also persons who want to become judicial officers.
Yes.
And so if you are willing to share a little bit about how do you negotiate that within yourself, because
well, I think what I have done, particularly if it's a very high profile matter, I shut out all the conversations about the case. I shut out all the newspaper articles about the case, and I concentrate more on the facts that are put before me. That is a conscious exercise. But I'm not saying that I will never hear about things. But what I have to do is not to take any position about what I hear. And so that I've heard all that people have said, that you should say that, or you should conclude in this particular way. But I do not wish to arrive at any decision. I say I must not arrive at a decision.
Yeah. But what I hear you say, Rolston, is that this is a conscious and intentional act on your part. And would you say that for a judicial officer, without that intentionality, it can be fraught, because you can get caught up?
Yes, you can get caught up in expressing views or taking positions silently that you ought not to take.
Yeah.
And one of the things you learn about law, about judging, is that you must never make any assumptions.
Yes.
Until the thing is proven before you. You must not make any assumptions. So you can't, for example, the basic thing, you can't assume a man is guilty because he's an adult.
Yes. But that translates in a very practical sense in this intentionality.
Yes.
That you have to be intentional about being impartial.
That's right. You have to be intentional about being impartial.
we've all sat on panels,
Yeah.
you know, like you, I was a first-year High Court judge, but also appellate, and now at the Apex Court. And when we have conversations with our peers, you know, there is often a thought that, well, are these judges influenced? It's a big question when we come to the Privy Council and the CCJ, and some constituencies that think that the CCJ is too close to people in the Caribbean to be truly impartial. And so this is an important conversation, I think,
Yes.
because I think part of what I hear you saying is that as a professional judge, you develop the skill to be impartial, even though you are in the midst.
That's right. It's something you have to consciously develop.
Yeah.
And you will see how other judges navigate situations and try to follow that.
Yes.
You know, so that I think impartiality to the layman outside is something that is sort of an impression that he has. But I think it's because of the mistaken impressions that people may have outside that you have to make that effort to make sure that you're not you're not sucked into impartiality.
Yes.
To partiality.
To partiality, yeah. Absolutely, yes. Yeah.
And it's easy to be sucked into that. You don't want, for example, if it's a union case, you don't want to be seen in a union dinner party or something like that. You know?
Yes. And what I also hear you saying is that even internally, to suspend judgment.
Yes.
Not to rush into judgment.
Not rush into judgment.
Yeah. And these are things which for the public and for judges who are thinking about persons thinking about becoming judges, or judges who've just started, these are skills that you have to practice and develop.
That's right. Yeah.
Also, let's shift a little bit more, if we can. And you've been a judge at very senior levels. Of course, you've been a senior practitioner. What would you say are some of the more common missteps or fallacies that you see in both legal submissions by attorneys and in judgments? Because you've sat at an appellate level all your life as a judicial officer. So, as you reflect, and so this part of the conversation we hope will be beneficial for practitioners and again for judges, because what are the gaps that you see or have seen?
I think with lawyers, I think exaggerating one's positions a great mistake. There are always pros and cons, so that if you take a good point and try to embellish it too much, it loses its force. If you oversupply the court with authorities, again you do yourself a disservice, because no two authorities say the same thing. So that at the end of the day, while the lawyer thinks that he is pressing home his point and he's making it better, he's in fact making it worse. The other thing is that an important thing in law generally is clarity. And submissions that are overly long are going to lack in clarity. The most effective submissions would not be that long, because they will summarize the points in short, not necessarily sentences, short paragraphs, which will bring home which will have a better effect than a long paragraph that's just meandering from one point to the other. I think that's one of the mistakes I think that young practitioners make. as regards judgments, I think one of the things I was told very early on is that I must not try to decide issues that are not before the court.
Mm-hmm.
Stick to what is in front of you. Why? Because you know, there's so many different situations that might arise in the future that you have not considered that will make your venture into the dark
Mm-hmm.
quite unmeritorious.
Mm-hmm. Mm-hmm.
So that you stick to what is before you, because you have all those facts in front of you, and you decide that. You may, of course, make a suggestion that that might be considered, or something else might be considered. And I saw a recent judgment from the Caribbean Court of Justice. I think it was Guyana Geology and Mines Commission, in which both yourself and Justice Witt are saying, look, you mightn't have thought of this before, but when you are doing judicial review in the Caribbean, in a constitutional context, you got to look at the Constitution.
Mm-hmm. Mm-hmm.
And so that judicial review in the Caribbean has to be looked against the backdrop of the Constitution. And I thought that was a very profound warning to the profession.
Mm-hmm.
Well, it's guidance, really.
Mm-hmm.
I think it's an important guidance to the profession. And I don't think the profession has yet realized that how important it is. Take, for instance, the issues that have arisen in Trinidad about publication of the fees paid to certain lawyers. Now, it seems to me that that is a fundamental breach of the express right to privacy. And why is it, if it's a breach of the right of privacy, and I'm not saying it necessarily is, but I think it is. If it is, then you've got to look at the Constitution and say that certainly nothing in an ordinary statute can override the Constitution.
Mm-hmm.
And I say the same for parliamentary privilege. A parliamentary privilege is saying that the parliamentary privilege in a constitution-based country is different. I think both you and Justice Witt said that.
Mm-hmm.
So that it's going to be parliamentary privilege must be looked at in the light of the Constitution, so that you can't, the scope of parliamentary privilege is going to be defined,
yes,
more or less, by the Constitution.
Yes. I'm very happy with this conversation. I think this is a very important area that we're talking about. I want you to continue, but I want to frame it in a slightly nuanced way for you to return to engage in it. You went to Oxford and sat at the feet of Wade.
Yes, that's right.
So, administrative law, Wade and Mark.
Yes, yes.
That's what we read. That's what we studied.
Right.
So, given those origins and what we're talking about now, because of course that's in the context of parliamentary supremacy,
yes,
and so on and so on. So part of my question to you now is, as you reflect on because administrative law, judicial review, constitutional law, that has been one of your fortes. Of course, there are others, commercial, etc., corporate, and so on. But in this little context, in this stream that you started off, you're landing off, get the ship for 12, 15 days, Southampton, the train, you land in Oxford. Professor Wade, administrative law, that's where you start.
Yeah.
Looking back at where you are now, how has your thinking changed?
Well, it changed drastically because, in those days, as you say, an unwritten constitution, and Wade is struggling at that time to tell the judges, look here, the judges can review administrative decisions, and he's defining the scope and so on. So there's a sort of in those days like a sort of secondary tier of law, which people didn't take to administrative law. Don't worry with that.
Mm-hmm.
But that has blossomed into a major element of law, and
in fact, one may say in the Caribbean or in Trinidad and Tobago in particular,
yeah,
it's become
I think it's that new generation which followed me. They now
mm-hmm.
have picked that up,
Mm-hmm.
and they are also armed with the Constitution, and they are saying, look at the Constitution.
Mm-hmm.
Review, yes, we want to review all decisions that are ultra vires or beyond the scope of the Parliament intended.
Mm-hmm.
And we also want to look at everything in the society in terms of the Constitution. And I think that's a new way of looking at it.
Yeah, it is. I have to accept some responsibility for that shift.
Because the younger generation.
Yeah, the Constitution is at the center, and it is impacting the entire legal order.
That's right. Yeah.
Its impact, but it's interesting because you've had this long career in the field, and today you sit here and you say, but that's what it should be.
Yes.
That's what it should be.
Yeah, and a lot of it has been stimulated by the young lawyers.
That's interesting.
What is interesting about it?
So are you saying then that in the development of your own career, your conversations with younger lawyers and practitioners that has influenced your own growth?
Tax law, for example. Now, that used to be a very arcane, well, still is a very arcane area, but if you take like Section 67, where the Board of Inland Revenue can deem a transaction to be artificial and fictitious. In the old days, you would come up with complicated formulae as to what is fictitious, what is artificial, and so on. But I think that is a lot of that is missing the point that the Parliament has invested the Board of Inland Revenue, a public authority, with certain powers, and that is the deeming power, to deem what you are looking at to be artificial. I don't think really it makes much point trying to find a lot of cases which say what is artificial and what is not artificial. Because at the end of the day, it seems to me that if Parliament has given that power to the Board of Inland Revenue, you're stuck with it. Now, you can say you should amend the statute, but I don't believe that the judges ought to now decide, well, I don't think the Board of Inland Revenue is correct. The Board of Inland Revenue was given that power. I mean, judicial review, I don't think, would extend to substituting the view of Mr. Justice Nelson for the view of the Board of Inland Revenue. I think that's a very important point. And I think there's a recent case, Methanex, in which the Privy Council is doing exactly that.
Exactly. And it has created a lot of debate.
Yeah.
And with great impact and implications in the region. Huh?
Yeah, exactly.
That's that. What I hear interestingly in this is this tension between precedent and first principles.
Yes.
And so even with the reliance on constitutional values to interpret questions around privacy or privilege or other statutory interpretation, there is there a tension between precedent and first principles, and where do you land on that in terms of your legal reasoning if you're faced with, there are precedents that have said this, but when I look at, as you say, the delegated power given to the BIR, which is a first principle position,
Yeah.
you know, I don't need to look at too many cases because how are you resolving that?
I can't say that I have totally resolved that. Now, precedent is a device we use to create the illusion of certainty in law. It's sometimes a means of controlling judges. Don't waver too much from what the others said. They said that for so long. But there comes a time, I think, where you really have to depend on the ingenuity of the judge to travel and circumvent precedent. And I'm not saying that in a bad sense. I'm not saying that judges should do something wrong. But I think I value precedent. I think precedent is important. Why? Because it gives an impression of legal certainty, which we know doesn't really exist. But the man out there, he needs to know, well, if I do this transaction, it will not succeed, so I need to do it differently. And that is for the general public. But I think at the end of the day, you're going to come eventually to a point where, the human behavior is such that you really have to look again at what is called precedent. And even the Privy Council, look at what they did in Matthew and Rudolph. When they are convinced that they're wrong, they change the precedent. Well, put it that way. At first, that's not really quite correct, because that was a question of the composition of the court.
No, but the precedent changes.
Yeah, the precedent changes.
The precedent changed from one panel to the other,
exactly.
and the law changed.
And the law changed, yes.
And the law changed.
Which is,
I hear undertones in this, again, coming back in our conversation to fair and just.
Yes.
In this filtering of what is fair and just, we must also not uncritically genuflect the precedent.
That's right. I think at the end of the day, the obligation of the judge to arrive at a decision which is fair and just is the main should be the main thrust of his thinking. Realizing, of course, that you still may not get it right, but you have to make a decision. The thing about judging is that you have to make a decision, and I see
at the minimum, that is what we signed up for.
Exactly, that is what you signed up for,
and you should give some reasons for the decision.
Exactly, and it is that the obligation to give the decision and to give reasons that is the problem. Where you have at the back of it, you've arrived at a decision. Now you have to work back and say, well, why is that right? So that what is interesting is that the non-doctrinal figures, the hidden assumptions may have got you to that point. And you have the difficulty now, and that is why some judgments are delayed for so long, trying to rationalize, how did I get here? That is the difficulty. And, so it takes a lot of analysis at the end of the day. Churchill used to say, out of intense complexities, intense simplicities arise.
Yes.
So that, it's a breaking down of the complexities.
Yes.
Breaking it down to simple issues.
Yes.
That helps you to arrive at a decision that you can justify by reason.
I think that's so well said.
Yeah.
I want us to shift again a little bit. Now, we say reasonable people can reasonably disagree.
Yes.
So, we're all let's assume as judicial officers trying to do what is fair and just.
Yeah.
But yet still you can have dissenting opinions.
Yes.
Reasonable people can reasonably disagree.
Yeah.
You can also have concurring judgments. That is to say that Rolston and Peter can both agree on the outcome, but we take very different paths
Yes.
to get there.
Yeah.
Now, I raise that to ask this. Different judicial officers, it would appear, have different methodologies or preferences for reasoning that they deploy when they are faced with a case. Can you help us understand that in your own experience? That is to say, the idea that you can have different approaches to legal reasoning. There are some obvious examples globally, we don't need to identify them, where clearly on a single bench there are some judicial officers who are going to reason in a certain way consistently and get an one outcome, and there are other judicial officers who are going to consistently reason in a different way, etc.
Well, I very much respect the independent road that a judge might take in arriving at his outcome. What I think is dangerous is that you may get a judgment with three different rationales. Let's say three different rationales, and the effect of that is to land the profession with great uncertainty and the inability to advise the public what is the particular answer in that particular situation. That is one of the things that I worry about with separate judgments. I don't know if you've noticed that in the CCJ, in the very early stages, there was only one judgment. Again, when you're building a court, you've got to be very careful not to have people uncertain about what the court is thinking. Now, as you have as the foundation is established, I think you can have that independence restored. It's not that people were prevented. It was a common decision. Look, we're building something. We're trying to establish a foundation. But at the point where each judge or a judge has a different view, a different way, a route of arriving at a decision, I think that has to be respected. And out of that, a lot of new ways may be found in later cases. And the profession is actually very keen on having judges state a different view in a different way, as long as it doesn't really create so much uncertainty. And I when I disagree violently but arrive at the same conclusion, I prefer not to write anything, because sometimes it may just cause more difficulty outside among the profession than before. But I think it's very important that each judge expresses his opinion in the way he arrives at it. That is important for the development of the law.
And I like the way you put that. That is important for the development of the law, because there is a way in which the law is dialogical. That the evolution, the development of the law is through these conversations over time. But conversations between courts, first tier, second tier, apex court, but also conversations amongst on appellate levels amongst judicial officers. I remember as a young law student having to read judgments in which there were no paragraphs, there were no subheadings, there were multiple judgments, and the task was to discover the ratio.
Yes.
You first had to discover the ratio of the opinion, and then you had to discover the ratio of the case.
Yes, that's right.
And I notice in Canada they do a very interesting thing. They actually identify the variety seems to be embraced, but they identify, I agree with this part, but then I say this. So, but it's an important question at this time, I think.
Yes.
You say is at this stage, for example, in the development of the CCJ, what would you say is most facilitates the development of the law? That this era, there is an expression of how I have arrived at my position, or this restraint, and as you said when you were here at the CCJ, even if I violently disagreed with the reasoning but agree with the outcome, you would exercise restraint.
Well, of course, in the original jurisdiction, you really are, the ground is cut from on your feet.
Yes. Yes, absolutely.
Judgment.
Yes.
But
in the appellate jurisdiction.
But in the appellate jurisdiction, I think there's nothing wrong at the apex level in having different views as to how you arrive at a decision, provided, of course, that it's logical and it is something that is well founded on authority.
Mm-hmm.
I think that is that's what lawyers expect.
Mm-hmm.
Lawyers expect to be guided at the apex level by, if not one judge, more than one judge.
Mm-hmm. Mm-hmm.
Where they arrive at similar conclusions, it is not really a situation where you are confusing people, but you're just showing different routes of arriving at the same station.
Mm-hmm.
And I think that is that often suggests other ways of getting there.
Mm-hmm.
And eventually I think it encourages the development of the law.
Yeah.
Clearly, you don't want to have sort of dicta that are not relevant to the case.
Mm-hmm.
As long as it sticks to the main themes in the case, I think that's a very good thing.
Mm-hmm. Let's look to the future. If I were to ask you, what is your hope for the next generation of Caribbean legal thinkers? You were at that stage in our historical development, just around independence, going with this deep sense of, I need to return to build something.
Yeah.
Well, we're 60 years plus on.
Yeah.
So maybe a little bit of an assessment first of looking back. Do you think that you have been part of a movement that has built something from your return to now, and then into the future? What would your hope be for the future for Caribbean legal thinkers?
Well, I think the thing is that in the early stages, pre-independence and shortly after independence, a lot of the judges were really like, I don't want to say mechanics, but they were mainly factory hands in the sense of just putting the things together and giving the answer. What happened, I think, after independence was that you had judges like Georges and mainly Georges, and whose judgments are being approved at a high level in the Privy Council. For example, in the LaSalle case, you had Clement Phillips' judgment being where the Privy Council said, Lord Millett said it was an illuminating judgment from which their lordships have derived great assistance. So that the maturity that developed there, where you have local judges really of the standing of an apex court, that happened, and we're now in a process where you are having local judges who are looking at a law in the Caribbean in a different way. They're looking at it from the point of view of a constitutional democracy. They're looking at it on a comparative basis with what is happening elsewhere in Australia and Canada. So I think when you see that, when you realize that there is that capacity for local judges to have international standing and recognition, as has already happened, I think you know that the future is secure, and you know that the region is capable of being well, I don't say governed, but of having judges who are looking at the rule of law in its particular dimension in the Caribbean. Mm-hmm. I think that is, and I think it's important to look back at what has happened, to look back at some of the early judgments, to look back at some of the academic contributions, Carnegie and people like that, Professor Menon and those. Those are the foundation which we have established here. And we realize that in the future we'll have great legal thinkers arising out of it. We have the material right now.
Yeah.
Great legal thinkers within the Caribbean who have international standing and international recognition. And I think that is what I am looking forward to, greater recognition of our judgments. In fact, CCJ judgments have been cited in the Privy Council. Mm-hmm. CCJ judgments are cited in other countries.
Yeah.
So, and also in academic journals.
Yeah.
So that for the future, I would like to see that maintained and encouraged. And again, if the younger people were to pay attention to exactly how that happened and how it is continuing to be observed, I think we have a very bright future.
And I think that is such a optimistic and hopeful statement that certainly resonates very well with me, and I'm sure with a lot of the people who are going to listen and see this. Ultimately, law is a service industry. The ideas of fairness and justice are fairness and justice for real people with real lives in real places.
Yeah.
This evolution we're talking about, do you think, looking at it as you can from where you can sit and look at it from, do you think that the law is developing as a Caribbean jurisprudence that is not only being recognized in international spaces and or acclaimed, but that it is also serving better the needs and aspirations of Caribbean people? Is this project of Caribbean jurisprudence only resonating in the spheres of academia, or is it landing in the lives of real people in the Caribbean?
Yeah, I think it is resonating with the local population quite a lot, and it is it's recognizable in decisions like the Chandler decision. It's recognizable in decisions like the McEwen decision. it is recognizable in no way. So the Barbados government immediately changed the statute.
Or the Maya Alliance.
Maya Alliance.
To provide land rights for indigenous people.
Yeah.
Yeah.
First time as I know that there was recognition of Maya land rights.
Yeah.
So that it is exactly on course to make life better for the Caribbean people.
Mm-hmm. And in that sense, we can have a sense of hope about Caribbean law.
Exactly.
Yeah. As we sort of wind down a little bit, Rolston, is there a principle or insight that you have stood for in this legal context that you hope could endure? Is there something that really matters to you?
Well, I think, as I said, the fairness and justice, the outcome of judicial activity really should be in everything that the judge does. But I think, in a broader context, the much of what is said in the preamble to the Constitution would encapsulate what my general insight into law, the respect for human dignity, the respect for human rights, the hope that everyone should have an opportunity to develop his full potential, and that the rule of law is really the means of keeping the country together, keeping the societies together. Those are the main concepts, I think, that I would say dictate how I look at the society today.
And I get a sense, therefore, from you that this distinction between rule by law and rule of law, for you, rule of law has a substantive, what is called by the academics, thick content, in which human rights values are integral to rule of law. Yeah. And in that way, the law serves the people.
That's right.
As you located in the preambular statements.
Yes, the preambular statement is really the consensus statement of the society.
Yes.
You see, and that is what really should dictate how a judge looks at any particular case.
Yeah.
You see.
Yeah. You say that so almost casually, but that's a radical statement, right? It's a very radical. No, to assert, if you had asserted that 20 or 30 years ago,
you're crazy.
But you are asserting that the preambular values should influence the interpretation and application of every law and governmental action.
Yeah, I agree that. Saying that 20 years ago, I've lost your job.
Yes. Yeah.
But a lot of the Caribbean jurisprudence has pushed us down in that direction.
Yes.
That we now recognize the preambular values as being the mission statement.
Yes.
Of the entire.
And you support that movement.
Yes, that movement has to be supported.
Yeah.
Because it is the agreement of the society as a whole.
Yes.
As to what values do we have? And law is about the normative values in the society. And if you take that as the foundation and the starting point, then the adjudication of laws must refer back to that.
Yeah. Which was the point you were making when you were talking about parliamentary privilege or disclosure of things in relation to privacy. Everything in the legal order has to be filtered through these basic values.
That's right.
Yeah. No, this has been a wonderful conversation. And as we come to the close, anything you want to leave or view in public with, or listen in public, you know, that you think would be something that you want to share as you have reflected, maybe out of our conversation, or something you've been reflecting on over time in terms of both your legal and judicial career?
Well, I think in the post-colonial era, we have to have more confidence in ourselves, and we need to have faith in the constitutions which we have set up. If we have faith in the constitutions we have set up and confidence in ourselves, I think the future is well assured to us. That's what I would say as a parting comment.
It's been a great pleasure to have spent this time together with you, Rolston, and we are deeply grateful at the CAJO, the Caribbean Association of Judicial Officers, for the opportunity for this conversation. And I want to thank you especially for the candor of your sharing, for disclosing bits and pieces of your life story, your journey that I'm sure maybe many have never heard, and maybe even some of your friends may be unaware of some of the early adventures. But thank you very, very much. And we continue to wish you the very best.
Yes, well, I must say thank you very much for inviting me in this august company. And I have certainly felt great pride in being a pioneer in legal education and seeing the positive results that have emerged both in respect of the deceased Dennis Morrison and in respect of yourself and others. So I think one feels a sense of achievement, a sense of success at the end of the day. And this is a fitting way for me to express that and say to the judicial officers, a lot of whom came through the system that we set up, that I am greatly proud of what has been achieved.
Thank you very much to Rolston Nelson, who is in fact a pioneering judge and person. Rolston, thank you very, very much.
Thank you very much, Peter.